the floor. So without further ado, Waikwa, for your overview, please.
Thank you very much, Dr. Walikala, and thanking the Center for the invite. So what I'll do is I will sort of lay the background, and for the benefit of the people, the background is actually in the judgment. So that's how I'm capturing sort of the background. And then I'll just go ahead and discuss the court holding. I won't discuss every holding. I'll focus mainly on 4 key holdings, which I think are the most significant and most enduring, and that I think relate to aspects beyond Kenya. So just to begin, for our listeners who may not have interacted with the Kenya constitutional making process, Kenya became independent in 1963 and got one of those Lancaster House constitution. However, soon after that, the government of the day started amending the constitution quite rapidly. There was significant amendment in 1969. So before the 2010 constitution, we used to refer to the old constitution as the 1969 constitution. And then, and when you go into the judgment, you find the judges discuss what they call the hyper amendment culture of the Kenyan constitution. Then there was significant restriction of civic space, which brought about agitation for a new constitution. And in 2010, a new constitution was promulgated. But before I talk about the features of the 2010 constitution, just 2 key dates. The first one is 2007, 2008, when we had elections in Kenya, and that ended up with serious violence, and including the requirement that the then UN Secretary General, just retired, Kofi Annan, had to mediate. And it's actually as a result of that that the 2010 Constitution was born. But the process of making the 2010 Constitution had started way back. And in fact, in 1999, a commission to make the Constitution was launched. That commission finished its work in 2004. The government didn't like the draft that the commission brought, so it tinkered with the draft. 2005, they presented a tinkered draft to a referendum, and the people defeated the draft. So the 2010 Constitution largely mirror what had been developed by the commission, save for certain things, including changing the system of government from presidential, from parliamentary to presidential. So we have a presidential system of government. What is key about the 2010 Constitution, it's the centrality places on the people, including the aspect of public participation. But also key, which is significant for purposes of today's discussion, is the creation of a very strong and independent judiciary. And what one key thing, and now I'm moving to how we get cases into court, is the Constitution has also provided a fairly robust enforcement mechanism, one of which is to give a very vibrant standing. So anyone who has concerns about compliance issues with the Constitution by anyone, they're able to present those issues to court through public interest litigation, and the court is required to take jurisdiction without resort to technicalities about standing. So because of this, the court has received serious backlash, because the court has been getting more and more what people would describe as political cases, but in actual fact, it's check on public power. One of those significant cases is the 2017 presidential election decision. In 2017, we had a presidential election, and the Supreme Court has the jurisdiction to hear a contest on presidential election, and it invalidated the presidential election, which again resulted into significant backlash on the court. But what was important in the repeat election, which the leader of the opposition boycotted, after that, because of the instability in the country, the two leaders, that Uhuru Kenyatta, the current president, and Raila Odinga, the opposition leader, came together and started what now we call the Building Bridges Initiative. It's this Building Bridges Initiative which turned into a task force, and a task force that recommended the amendment to the 2010 Constitution that brought about, or was the result of, the litigation. What I would want to underline here is that the Kenyan Constitution has never had any amendment since 2010, even though there has been significant attempt by politicians to change it. Some of you who might know of Professor Yash Palgai says that the Kenyan Constitution is the constitution that the people imposed on the political elite, and the political elite are always looking for an opportunity to overthrow the people's constitution. So politicians since 2011 have actually brought numerous amendment proposals, but none of them have seen the light of day. Why Building Bridges Initiative, and now from here I'll be calling it BBI, was so significant is because the two leading politicians in the country, with all their political infrastructure, came together and were agitating for constitutional amendment. Let me then pause and talk about the manner in which you can amend the Kenyan Constitution. There are two ways to amend the Kenyan Constitution. The first one is through a parliamentary initiative, which most of us would be familiar with. A member of parliament introduces an amendment bill in parliament. If it gets two-third reading in both second and third reading, then it's considered that the amendment has passed. What is unique, or slightly unique in Kenya, is that between the first reading of the bill in parliament and the second, the bill has to sit for 90 days. And that time is to facilitate public participation. Just going to the point I was making earlier about the centrality of public participation. So that's one way. The second way is through what we call a popular initiative, which is a process that is started by, or it's intended to be started by the electorate. And as we'll see, this becomes a contentious issue in the litigation. And the way that is supposed to work is electorate propose an amendment. They go and collect 1 million signatures, present those signatures to the Independent Electoral and Boundaries Commission. If they are verified, they are taken to county assembly. We have 27 county assemblies. If at least half of them endorse the amendment are sent to parliament. The role of parliament on a popular initiative is very ceremonial or secretarial, which is just to debate and vote. If they vote to approve the bill and it's not the kind of bill that requires a referendum, then the bill passes. But if it's the type that requires a referendum, then it's sent to a referendum. But if they vote to reject a popular initiative bill, it's sent to a referendum, whether it requires a referendum under Article 255 or not. So let's just then, I knew I had about 15 minutes, so I have about a few of that, a few minutes remaining. So I just want to focus now on the judgment, and I know there will be more discussion. So the case comes to court challenging this effort to amend the Constitution through BBI, and 8 petitions in total are filed. Of these 8 petitions, they raise a myriad of issues, issues that goes to the substantive issues of amendment, but also issues that go into process. And Kenyan Constitution is very strong on respect of process. So I wanted just to focus on 4 key findings, which I think are critical. The first is whether BBI was a popular initiative. The second is the finding on basic structure. The third is whether there is adequate legal framework to facilitate the amendment of the Constitution. And the fourth is usurpation of powers of the Electoral Commission by the task force that prepared this bill by seeking to delimit electoral boundaries. So what did the court say about popular initiative? So when you go to the Constitution, Article 257 to be precise is the one that provides for popular initiative. And as I said, it says that a popular initiative will be proposed by a voter with the support of 1 million signatures. The question was, can the president then, as president, initiate a popular initiative? And what the court, and the second part to that question is, can the president or any state officer use public resources to launch a popular initiative? And what the court said is that popular initiative is the pathway that was preserved by the Constitution for the people and as voters to seek constitutional amendment. Any state or public officer who wants to seek constitutional amendment, they have the parliamentary route to use. And so they cannot purport to go through the popular initiative. The court also found that the president was in a unique position because the president is the one who makes the final call after the passage of the bill, whether it should go to a referendum. And what the court determined is because the president at some point plays what they call the umpire or referee role, then it would be too untidy for him to also be the one sponsoring a popular initiative. And for that reason, they found, or the court found, that BBI process was not a popular initiative. The second finding is on basic structure, and this is, I think, the one that has generated the most interest. And I don't have time to go into the history of basic structure. I'm sure Sylvia and Abrina will also be talking maybe a bit about this. But the question was whether the Kenyan Constitution has a basic structure and what that basic structure is. And the court found that there is a basic structure, and the court found that there are 2 levels of how to deal with basic structure. The structure that you cannot change under whatever circumstance. The only way to change it is through a constituent assembly when you're making a new constitution. The second is the basic structure that is not as protected, but one that would require significant involvement of the people. And the court delineated 4 processes under which have to be met for any provision relating to basic structure that can be amended has to undergo, and that is civic education, public participation, constituent assembly, and then a referendum. And what is interesting here is that the specific question that had been posed by the first litigant was whether there are specific chapters and specific provisions that are protected. The court didn't get into that. What the court seems to say is that there are certain features, some of them which constitute provisions, some of them may even constitute chapters, which are protected under the basic structure. The third finding is on adequate legislative framework. We don't have laws to guide the processes, and given what I've just said, the processes are fairly complex. And so the question there was whether the president could have gone ahead and sponsored and facilitated constitutional change without a facilitating legislative framework. And the court said, no, you need a legislative framework to guide different phases of the amendment, whether it's the phases on signature collection, all, it's on the phase on verification of signatures, the phase at the county assembly, and eventually parliament and referendum. Finally, if I may take just one last minute on the fourth finding that I wanted to underline, the usurpation of the mandate of the Electoral Commission. In a way to make the bill appeal to different sectors of political actors in different parts of the country, what the proposers had done is to actually add 17 new constituencies, propose 17 new constituencies, and even distribute those. However, 2010 Constitution says that the role of delimitation, first of all, the role of determining whether there is a need for additional constituencies and delimitation is to be done by the Electoral Commission. That provision that gives the Electoral Commission those powers was not being sought to be amended. So the court said you can't do it. You can't take over somebody else's constitutional mandate and purport to exercise that through the back door. And for that reason, also the court found that the bill was infirm. I would want to stop there. During discussion, one thing I would want to highlight maybe is about multiple questions referendum. But let me pause there, Dr. Walikara. Thank you.
Thank you very much, Waikwa, and thank you very much for sticking to time as well. But that was a really comprehensive and very clear introduction to the main issues in the judgment, as well as also, of course, your preliminary remarks about placing the whole thing in context, which was very important and useful. And you immediately see, given Kenya's post-colonial constitutional development, why this has so much resonance. What's going on for countries similarly placed. But thank you very much for that. And next, for a law and society perspective, Professor Ambrina Manji.
Thank you very much indeed. And thank you for the invitation to be here today. I want to preface my remarks by saying that in truth, I'm not a constitutional law expert, and I think that's really important to say. I'm just a common or garden land lawyer, so do take my my comments in that spirit. I only really study constitutions insofar as the issues intersect with land issues in which I'm interested, and so I always benefit immensely from hearing erudite accounts from scholars such as Waikwa, who I think has given us a really important insight into why this judgment has been received as it has, with great commentary and excitement about various aspects of the judgment. Let me make my comments on reasonably narrow ground. And that is to say that all commentators who've written about the BBI judgment have included in their analysis so far reflections on how the court has been attentive to history and treated history, specifically Kenya's constitutional history since independence. And I want to focus on that because I think there are important insights to be gained from looking at the work that the court did in relation to history. So what the court essentially did was to find in Kenya's constitutional history a guide to the people's intentions. So it asked itself, what were the people doing when they bequeathed to themselves this 2010 constitution? And the court reasoned that although there's no clause in the constitution that explicitly makes any article in the constitution unamendable, the scheme of the constitution, coupled with its history and structure and nature, creates what the court calls an unmistakable conclusion that the power to amend the constitution is substantively limited. And this goes to many of the points that Wyke was raised. And the court read into this history the idea that the Constitution itself makes it plain that it was the desire of Kenyans to barricade that Constitution against destruction by political or other elites. And commentators have all pointed out that this basic structure doctrine, which has been elaborated by the courts, rests very much on the foundations of Kenyan history. And they've carefully analysed what work history does in the judgment. What I want to try and suggest here is that the inverse is also an interesting question. What work has law done for history? What does it mean when a court rehearses history in a judgment in the way that the court did here? And to answer that question, I think I want to suggest that we have to see the BBI judgment as the most recent in a line of judgments in which the courts explore history. And I want to say that because I think without that recognition, we misread the BBI judgment, but by seeing it in isolation, as the court being involved in a historical engagement when it needs to bolster basic structure doctrine. But I think there's more going on than that. In truth, I think we can see a line of cases in which the courts do careful historical work, archiving the constitutional struggle in ways that I think are important. I'm going to discuss just briefly one of these cases. And this is a case that those of us working in the land domain will know well, but which actually has been largely neglected by others. So in 2014, the Supreme Court issued an advisory opinion on land. The court was asked to rule for the first time on a key question in relation to land administration, and that was, what are the responsibilities and duties of the institutions envisaged by Kenya's new legal framework for land governance? In other words, the relationship between what we call the Land Ministry and the new National Land Commission. And in order to answer this, the Supreme Court expresses really explicitly a desire to, in fact, a need to understand the country's history in relation to land. And the Supreme Court argued that there's a need for a historical and cultural perspective when interpreting the Constitution, and that it was only by this means that the court, by taking into account this historical perspective, that the court could fulfill its mandate as set out in Section 3 of the Supreme Court Act 2011 to develop rich jurisprudence that respects Kenya's history and traditions and facilitates, and I'm quoting, its social, economic, and political growth. In other words, the court felt itself compelled to take into account Kenya's particular land history. And so the Supreme Court, in this advisory opinion, rehearses this very rich legal history as it relates to land. It makes a commitment to bring history to bear in its decisions, in this particular decision, and draws on earlier advisory opinions in which Chief Justice William Tunga also elaborated on the way in which history might be used to understand the Supreme Court, or used and mobilized by a court which he described as having near limitless and substantially elastic interpretive power. And it seems to be that the Land Commission advisory opinion is perhaps one of the best rehearsals of Kenya's land history that we have. And it makes the connections very explicitly and actually at great length between land reform and constitutional transformations. And it seems to me that that advisory opinion presented an important opportunity to understand the principles as set out in the Land and Environment chapter 5 of the Constitution, and how they have fared in the difficult translation from the aspirations of the constitutional to concrete laws and then to everyday practices. And of course, the status and importance of that judgment is undeniable. It's issued by the country's highest court. It's a ruling on a rare ruling on matters of constitutional law and land law and their interaction with each other. So turning now to the BBI judgment, on reading it, if you know the Supreme Court advisory opinion, you'll see a similar level of engagement with history in the BBI judgment too. And it seemed to me that it's important to draw attention to that this is not the first time that we see the Kenyan courts doing history work in really quite impressive detail. So in the BBI judgment, what we see is the court relying once again on the writing of the Chief Justice Chief Justice William Mutunga, as he then was, and his reflections on participatory constitution building and what that means. And it's the court cites him saying that what we have before us is a story of ordinary citizens striving and in some cases succeeding in overthrowing an existing social order and trying to define a new social, economic, cultural and political order for themselves. And some, he says, have spoken of this new constitution as representing a second independence. And the court held in the BBI judgment that a detailed grasp of Kenya's constitutional history was essential, just as the advisory opinion did. It was essential to understanding, considering the matter before it. And it rehearses this history to explain what happened to the independence constitution and the resultant situation of an overweening executive so that by the time Kenya became a multi-party state in 1991, the constitution had been stripped of most of its initial democratic and social justice protections, and the country had effectively become an authoritarian state. Gautam Bhatia, writing on the BBI judgment, has noted, and I think he's quite right, that the entire analysis focused on how Kenyans struggled for and won the right to public participation in constitution making, and that was the basis for holding that the core of the constitution couldn't be altered without going back to the people. Similarly, Jill Cottrell-Guy and Yashpal Guy have written that the High Court used history to exclude the possibility. They considered the possibility and then used history to exclude the possibility that having gone through this whole complex participatory process to get a new constitution, the people would accept or be happy to allow it to be changed in fundamental ways by a process that wasn't people-led or people-centered. And in his turn, Joshua Nyawa has written in a very perceptive reading, I think, of the BBI judgment that I think can be extended to the land advisory opinion that I've just mentioned, that what the court was doing was emphasizing that the Constitution of Kenya, the 2010 Constitution, is both monumental and memorial. It's monumental because it celebrates this achievement, of change, but it's memorial because it reminds us of past, what he calls past atrocities. So what do these two examples of courts doing history have in common? The advisory opinion on land and the BBI judgment. They show that the shape and future of the Constitution is not all that is contested. So too is Kenyan history. And both judgments engage with that dilemma, that problem. So what is and should be an authoritative account of the period of constitutional reform is up for grabs in the land domain, in the advisory opinion, and in relation to BBI in the more recent judgment. Let me go on here a little bit to just to try and confront some recent critiques of that idea of history's centrality to the BBI judgment. But he has written that what this judgment does is to rely upon an expanded, what he calls an expanded interpretive canon, which centers the people and centers social movements in understanding constitutional meaning. And he describes the judgment as recording a radical social history in the same way as I've suggested in the past that the advisory opinion on land does. In response to that suggestion, Rafael Brides has noted that much has been made of the court's reliance on history, but it's important to note from the start, according to him, that such reliance is by no means a politically neutral endeavor. And so he argues that the specific reading of the constituent past being made by the judges is not free from its own normative baggage. And he says the problem with framing the issue in these terms is that what the people meant when they gave themselves the Constitution is not just something to be seen or recorded. On the contrary, it's an inherently contestable claim. So he says, in concluding that it was indeed the Kenyan people who bequeathed themselves the Constitution in a successful struggle, the court is essentially trying to settle the meaning of the constituent demos by identifying it with the participants in the constitution making process. Despite, he says, all the other political choices and power dynamics that in fact did help to frame the participation, and that the court translates this into a uniform popular will. And he says what that does then in the judgment is that the judgment's narrative obscures these contestations. And I think on reflection, I think it's a really important rejoinder to those of us celebrating the judgment's treatment of history. But I think overall, in taking into account the advisory opinion on land, I think I disagree. I think that the judgment in the BBI case doesn't seek to obscure the contested nature of Kenya's constitutional history. On the contrary, I think it seeks to record it almost for future generations, along the same lines as those of us who know the Kenya Human Rights Commission report entitled Wanjiko's Journey, which records the struggle for constitutional change in a lot of detail, is really aware, that report is really aware that the generations are passing, and those involved in the struggle for the constitution, their effort or their work needs to be recorded somewhere, that short of that we're in danger of losing knowledge of the struggle for the constitution, and we're in danger of forgetting how during that constitutional struggle there were concerted attempts to mislead the people about proposed constitutional change. So, for example, in relation to women's rights, to reproductive rights, to sexuality, and to land, there were concerted attempts which the Kenya Human Rights Commission report records in detail, precisely to mislead the people. So the contestation is laid bare in reports such as that. What the BBI judgment seems to me to do is to draw on a rich theme of Kenyan historiography concerned with how ideas of justice and fairness are constantly contested. It doesn't deny that contingency, but in my view, stares it in the face. And I'll leave my comments there.
Wonderful, thank you, Ambrina. Really, sort of lots of food for thought on that extensive but very fair reflections on the judicial use of constitutional history, and I think we can discuss much of that. There are a number of colleagues here at the Centre also who sort of have thought a lot about these issues, particularly in democratizing and transitional contexts like Kenya. And I'm sure there'll be lots of questions on that in the discussion. But first, and then thank you so for that. Then finally in our panel, my old friend and colleague, Dr. Sylvia Suteu, who is, of course, an alumna of Edinburgh. She did her PhD here with us on eternity clauses with Stephen Tierney, and was, when she was here, a very, very active member of the Centre and the public law community here. So it's very nice to have you back, Sylvia, and the floor is yours.
Thank you, Asanga, and thank you to everyone at the Centre for having me. It feels wonderful, if a little strange, to be on the other side of the wall, but a pleasure nonetheless, especially to to offer my comments on this judgment, which has, or gives me that rare chance to marry the two strands of my own research, which is unamendability and entrenchment on the one hand, but also public participation and constitution making on the other. So I've been asked to offer some comparative insights on the judgment, and I will do so along three axes, fully understanding that will not exhaust the range of comparative interest that is raised by the judgment. So first, I will talk a bit about how the High Court judgment embraced the Basic Structure Doctrine, how it used context, what constitutional theory it relied on, and also the methodology and contours of the Basic Structure Doctrine that it embraced. Secondly, I'll speak a little bit about the elements regarding public participation and the link to the Basic Structure Doctrine that the court very interestingly draws. And thirdly, a few thoughts toward the end about how the court strategically positioned itself and its judgment in a context in which we can probably assume contestation, including in terms of appeals, is to follow. So first, the court's embrace of the Basic Structure Doctrine. So as you have heard from my predecessors, the High Court from the onset and repeatedly emphasized the need to interpret the Constitution holistically and contextually. And in Kenya's case, it clarified that this meant several things. So on the one hand, recognizing the 2010 Constitution's transformative character. So as a constitution born out of a highly participatory constitution making process in the aftermath of electoral violence on a large scale, and with distinctive aims of ensuring peace, but also societal change through law. So it is an important point that the court repeatedly emphasizes, that it is in that context that it looks to constitutional protection, including through the Basic Structure Doctrine. We've also heard from Ambrina just now about how the court relies on a reconstitution, a retelling of Kenya's constitutional history. And I think importantly, for the purposes of understanding its position vis-a-vis unamendability, it links that constitutional history to unamendability by viewing the Basic Structure Doctrine as needed to overcome certain past pathologies. So the hyper-amendment culture, where previous constitutions were too often amended and too extensively. At one point, the court says, it rendered the previous constitutions little more than similar to statutes. So losing constitutional legitimacy through this hyper-amendment culture. But another pathology, the imperial presidency that had arisen and this link to authoritarianism as the result of the expansion of executive power and the concentration of that executive power in the presidency, which the court saw happening again through this package of amendments before it. So it is in this particular post-conflict fragile context that arguments around the BBI and the Basic Structure Doctrine were to be interpreted. And in addition, and importantly again for comparative purposes, the court emphasizes that it needs to look at the whole constitutional structure, the whole constitutional edifice and architecture in order to assess the cumulative effects of the amendments, the amendment bill before it, and also not to isolate these changes or to read them in isolation from each other as well as from the rest of the Constitution. So there is a link here immediately to the preoccupation that we have as constitutional scholars to think through how to react to what we now refer to as democratic backsliding, where often we do see exactly this kind of piecemeal, incremental, cumulative constitutional amendments used to undermine the basic structures of various constitutions and democracy overall, and thinking through what tools courts in particular might use in order to respond and prevent precisely this kind of cumulative backsliding. Now I'll move to discussing a little bit the theory of unamendability that the High Court ultimately embraced. And this relied on a particular understanding of constituent power and the avenues open to amendment in the Kenyan constitution. So the court interestingly distinguished between primary constituent power, secondary constituent power, and constituted power. So constituted power would refer to ordinary powers of amendment. Think the avenues open to Parliament, for instance, to introduce bills and change ordinary or non-essential features of the Constitution. Secondary constituent power would, interestingly for the participatory minded among us, still include far-reaching participation from the people, including through referendums and the popular initiative mechanism stipulated in Article 257, but importantly for the court, would not extend to being able to change these essential features of the Constitution. And primary constituent power would refer to those instances where an extraordinary power is retained by the people to change the essential features of the Constitution. But as Whitewell reminded us, the court actually goes further. And this is where, as a participatory constitutional researcher, I found this very fascinating, because often courts, would make this distinction, which underpins the embrace of an unamendability doctrine in many other places, but leave it rather amorphous and say you would need a new constituent making process. You would need a primary or original exercise of constituent power. And that's not what's happening here. And then sort of move on to other matters. But what the Kenyan High Court says or does is it actually fleshes out what principles and what types of involvement, civic and public involvement, would be required to meet that threshold of the primary constituent power exercise. And Whitewell mentioned these: civic education, and they are substantive principles. It's not just sort of an afterthought. They talk about civic education to equip people with sufficient information to meaningfully participate in constitution making and constitutional change. So there is a substantive and normative sort of threshold there. Public participation and collation of views in which the people, after appropriate civic education, generate ideas on the type of governance charter they want and give their views about the constitutional issues. So not just consultation, but also agenda setting. Thirdly, constituent assembly debate, consultations, and public discourse to channel and shape the issues through representatives. So again, an active role as an agent rather than a recipient of sort of constitutional debates. And finally, the referendum to endorse or ratify the draft constitution. So a very meaty understanding of what that primary constituent power would actually entail. And this will be of interest to constitutional theorists and comparative constitutional law scholars who might be aware, I'm sure, especially in this crowd, of recent interest in scholarship as well about this question of whether the existing constitutional framework can actually accommodate this type of openness. So can existing constitutions actually regulate their own replacement, or can they inculcate rules for a future constituent process, or is that sort of the suicide pact, the nuclear option? Someone like Joel Colin-Rios has written, drawing on Latin American experience, that actually this type of openness can be accommodated within existing constitutional boundaries. And someone like Andrew Rato, probably drawing on sort of Arendtian skepticism of the general will, is very much cautious and thinks that that is just asking for it and for the constituent process to be captured by political forces. So here you have another actor speaking on this and showing a possible path forward to accommodating that type of constituent process within existing constitutional structures. I'll move on to say a few words about what I term sort of the methodology that the High Court uses to embrace the basic structure doctrine. So when it comes to defining what it means, what it understands by basic structure, and how that is to be distinguished from unamendability as such, we again find interesting material because the court distinguishes between possibly recognizing certain chapters or schedules in the Constitution as part of the basic structure from unamendability, rendering them unamendable as such. And it says, and gives the example, several examples, but one of them, for instance, electoral districts apportionment, where it says, you know, the number of electoral districts might be amended, but the process through which those districts are to be apportioned and shouldn't be, is unamendable. So the standard, the threshold the court says, seems to be one of destruction of essential features, as opposed to change, clarification, gap filling, which leaves the door open for, at least in some instances, some features and some provisions, it says, are definitely unamendable. So it recognizes certain sort of implicit eternity clauses in the Constitution, but it sidesteps the rather well, problematic arguments of some of the petitioners who had been arguing in their petition that the Constitution was born mature, that it has no infancy, and therefore, you know, these vast swaths of chapters and schedules should be declared unamendable in their entirety by the court. Now, it is to be determined whether that distinction between clarifying, filling gaps, etc., and destroying a particular provision is always as easy to draw. But that the court doesn't go into. It also, and I think Whitewell again mentioned this, the court also refused to provide an exhaustive list of unamendable provisions or elements of the basic structure doctrine, and that is not unprecedented. The Indian case law on which a lot of the judgment draws, including the Kesavananda decision, so the Indian Supreme Court similarly refused to pin down the basic structure doctrine and offer an exhaustive list. And as we know, through subsequent case law, it added, clarified, fleshed out various principles and elements of the Indian basic structure doctrine. And presumably, the High Court leaves the door open to such an approach as well. And also, again, from a methodological point of view, emphasizes that the question of what actually forms part of the basic structure doctrine can only ever be answered on a case-by-case contextual assessment. I could say more about it's reliant on precedent and the Njoya case that interestingly both sides actually invoke, but maybe we can leave that for the Q&A, because I want to say a few words in the remaining 2 minutes that I have on the use of comparative material that all sides, including the court, ultimately engage in. So this is always fascinating to see in a judgment, because it always reflects the parties' understandings of constitutional autonomy and also openness versus closeness of the constitutional system. So the petitioners had invoked India's jurisprudence on the basic structure doctrine, especially where the respondents had some very interesting comparative arguments on the use of foreign material. So for instance, they used comparative examples to argue that the basic structure doctrine as a doctrine was not universally accepted, and relied on cases such as Singapore, Malaysia, Uganda, Zambia, or Tanzania. I think, this is a textbook example of maybe sort of poorly constructed use of comparative material in pleadings, because the foreign jurisprudence cited was incomplete. It was, in many cases, outdated, and sometimes didn't even include some of the strongest possible examples. I'm thinking of Sri Lanka's example, which Sangha can say more about. So, there would have been more resources for them to draw on comparatively to actually argue that there are other ways, or that the basic structure doctrine is not the only path that could be accepted. More to be said there, but I'm jumping ahead to say also that the court itself in its judgment didn't just sort of engage with these citations from comparative material, but also relied judiciously on some comparative material. For example, when it discussed popular initiatives and the regulation of popular initiatives, it looked to jurisdictions as varied as Switzerland, Moldova, Venezuela, or Liechtenstein. I leave it to the comparatives to decide whether that is in itself a good strategy. But I found it interesting that for all the pleadings using and relying on comparative material, the judgment itself didn't seem to ultimately do too much with that. And I read that as an effort to not legitimate its embrace of the basic structure doctrine through this sort of global dialogue and use of comparative material, but rather to locally ground it, hence the emphasis on constitutional history and Kenya's context. I would have said more on public participation, but I think Waikwa covered much of that. I think just from a comparative point of view, it is a rich judgment that clarifies a lot about popular initiatives and where to draw the line when it is actually a veil for the executive to instrumentalize popular participation in constitutional change and to actually itself drive the constitutional reform process. And I think the court does a good job of facing that squarely and ultimately finds the president's action unconstitutional. And it's also interesting to note the connection here with unamendability, because you might assume that in a context very open to public participation, unamendability is sort of on the other side of that, and the two are in tension. But actually here you have popular participation used as a legitimating tool to argue in favor of embracing a basic structure doctrine. So the very fact that the 2010 constitution was adopted through such a highly participatory process is used by the court to substantiate its argument that there is a basic structure which the people had embraced and given themselves and which should be protected by it as the guardian against political infringement. Finally, very finally, a few words on strategy. So for example, who is the court addressing? It was very interesting to read this as an international, a non-Kenyan, because it seemed to also address an international audience in its use of and citation of comparative material and references to international standards, but also indirectly that historical reconstruction seemed to also speak to a non-Kenyan audience to understand the context in which this was being decided. There also seemed to me to be a direct appeal to higher courts, particularly the Supreme Court, for example, by citing retired Chief Justice Mutunga's views on constitutional interpretation in the Kenyan context, and to sort of try to insulate the judgment from accusations and from delegitimation that the court seemed certain would follow. So this thoroughness, mix of formal and non-formal, legal and non-legal arguments, and the unanimity of the judgment I read as a sort of clear strategic positioning of a court that knew it would find itself at the center of constitutional battles to follow. Thank you. I'll stop there and look forward to the Q&A.
Great, thank you very much, Sylvia. Lots there, and much to discuss and unpick. I'm sure there'll be lots of comments and questions.